following program on Ada Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the functions and features of the Personal Data Protection Act in Sri Lanka. How has this piece of legislation contributed to better tech security and privacy in the country? And is it on par with international standards? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty, where we bring to you key legal concepts and break it down for the layman. Now, tonight's topic is something that has been rapidly evolving over the past few months and years as well, and that's on the Personal Data Protection Act in Sri Lanka, and specifically on privacy and data protection in general in the country. To talk about this, we have someone that's very well suited for this program and is a bit of a new face on the program, and that is Mr. Shanaka, Gunasekara, attorney at law. So thank you very much for coming down to the studio today to explain this very vast topic to our viewers. I'm sure we're going to have a crack at it to include as much information as possible. A little bit of an introduction into our esteemed guest here. He is a partner at FG&J Desarum, which you would know if you've been following the legal field is one of the oldest law firms in Sri Lanka. He is the head of data protection and privacy in the firm, as well as a key player in the firm's telecommunications practice group. He also provides expert advice for both local as well as global clients, as FJ&J Desarum, the law firm, does participate in international clients as well, including with international law firms. So safe to say we're in very good hands for this specific topic. A bit of an introduction on how we're going to actually approach this topic. First, we'll be talking about the fundamentals, and next we'll be getting into the current context when it comes to the PDPA. And finally, we'll be talking about future implications and developments we can expect to see moving forward for data protection and privacy in Sri Lanka. All right, well, without any further ado, let's get right into the nitty-gritties of this topic. We have a lot to cover. Thanks once again, sir, for trying to attempt to cover most of the areas. I'm sure it's very vast, and considering your expertise, there's a lot of input. But I'd like to cover the basics before we get into any of the specifics. So could you please introduce us to what this piece of legislation really is? Can you briefly explain the purpose and also the function, the key objectives of the Personal Data Protection Act, which is active in Sri Lanka?
Yeah, so if we approach it in this way, so that it will be easy to understand. So as we know that in the modern day and age, personal data has become a commodity. So when something becomes a commodity, tradable in the market, then there should be some sort of a balance struck between the people who are using that as a commodity and the people who are providing it. Here in this case, the data subject or the individual. So when the personal data is being provided by the individual and when that is being used as a commodity, they should have rights over that. And what happened is that personal data protection came into being to provide that much needed balance, so that the individuals will have rights over the data they provide, so that there's a fair market is structured. And that's the beginning of the concept of data protection.
So what I'm trying to understand is the Personal Data Protection Act that was introduced is, as you would explain it, is basically a way in order to regulate the trading and also the commodity that is personal private information, right, sir? So I'd like to understand specifically how the Personal Data Protection Act really goes about in ensuring such a balance takes place.
So that is achieved primarily by empowering the individual. That is to say that up to this point of time, data subjects or the individual did not have any rights over the personal data. So the key difference that is being brought about by this particular legislation, it empowers the individual by granting rights. So say for example, if you are handling my personal data and if you are using it for your businesses, I am given right to ask what data you have, how you handle it, and then if when you are using it, you have to use it for legitimate purposes, and there is clear restrictions are being brought in to ensure that it is used for that purpose. And I am entitled to know what are those purposes, with whom you share the data, and after the purpose is fulfilled, data is deleted. Likewise, rights are granted so that individuals' participation in that commodity trade is achieved. So it's pretty much equivalent to like you have the Consumer Affairs Authority. And the purpose of the Consumer Affairs Authority is that the consumer is provided with certain rights so that there is a balance. So the trader is not able to exploit the consumer. Same concept. So the individuals are given rights and the principles are being established in the law, which becomes obligations of the controller, so that you must process the personal data, that is the trader or the person who handles personal data, we call that person the controller. He has to ensure that he processes personal data in accordance with those principles and also recognizing the rights of the data subjects.
Right. I want to get specifically into the details of what you just mentioned, this exchange, the empowerment that the Act brings to an individual in order to hold certain organizations that would be processing our data accountable. I want to talk about the salient features of this Act as well. So could you get us started on explaining that by trying to help us understand what types of personal data is actually processed and covered under this Act, and also how personal data in itself is defined in a legal sense?
Yeah, so now as you said, the starting point is to define personal data. So the personal data is defined in a way that any information that can be used to directly or indirectly identify an individual. And so say for example, a particular call log at a reception may not be, from the eyes of a third party, it may not be personal data. But an interested person can easily relate that to an individual to say that, okay, this is the call log of that particular person. So that's the indirect scenario. So both direct as well as indirect data is covered. So long as you can identify an individual using a particular data set, then you are handling personal data. So the moment you handle personal data, then depending on what you do with it, meaning if you are the person who's deciding the purpose in relation to that personal data. Say for example, if I'm a marketing agency, I would use the contact number and send the marketing message. So I'm determining the purpose that I want to send a marketing message to that particular person. I may do it for somebody else, I may do it as my own initiative. If I'm doing it as my own initiative, I am determining the purpose, I'm also determining the means. I will send it by email. I'll keep it for 7 years, or I'll keep it as long as I want. So the person who determines the purpose and the means of processing with regard to the identified personal data becomes the controller. And say for example, if the marketing agency is doing it for and on behalf of another business entity, then that entity becomes, then the marketing agency becomes a processor. So controller is it is on the controller the primary obligations are imposed. To a certain extent, processor is also liable, but his primary liability is tied up to adhering to the instructions given by the controller. So that's the legal framework broadly that has been established. So you have in the law the principles that the controller must follow and the legal framework that he must establish inside the organization. We call it data protection management program, that is to enable the rights as well as to recognize all the data protection principles so that you process the personal data in a safe environment, so that the individual's rights are protected, and when they want to exercise it, you have enabling mechanisms. That's I would say, the broad framework of the enactment.
So it's got three important parties: the controller, the processor, as well as the affected party that the data is being processed of. I want to get into what exactly, we should definitely break down each of these three roles and how exactly the Act covers them, but I'd like to start with what I believe the audience and us would actually relate to at first, which is the affected party whose data is being processed. Can you please explain to us, sir, what main rights and what protections are granted under the PDPA towards individuals that are having their data processed?
Yes. So let's begin from an example. Say for example, and I get to know that my personal data is being used by this particular trader for various purposes. So First thing I want to know is that what data you use. So that's called right of access. And then I want to get a confirmation from you that, okay, these are the personal data of you that I have with you, and so I need to get a copy of that. So that's the first right. That's the, I would say, the foundation of figuring out things. And then once I have the right of access, I also have rights like right to deletion, meaning this is what is called in the internet a right to be forgotten. So that if the purpose is fulfilled, if you collected that personal data for a particular purpose, then after that period is fulfilled and after the retention time period, if there is a lawful retention time period, if that is fulfilled, then I'm entitled to ask you, delete my personal data. I don't want you to keep that. That is also another right. Then you have, if the consent is obtained, if the consent is used as the lawful basis of collecting personal data. If I sort of deviate for a second here, that the consent we are talking about here is different to contractual consent. Probably we can talk about that a little bit more in detail. So, but if the consent which is identified under the Data Protection Act is used as the basis for collecting information. Say for example, I go to a supermarket and the supermarket says, if you give me your contact number, I'll be able to send you the latest product information as well as the discounts that I offer. And then I would have the choice, a genuine choice to say yes or no. Because regardless of my decision, I will be able to still obtain the services of the supermarket. So if I give the consent there, then I should be able to withdraw the consent at any given point of time. That is also right. So you would see these emails coming from, especially from the European Union based organizations, at the end of it to at the top of it, unsubscribe. That's the right that is being enabled. And then in addition to that, say you are dealing with a bank and you give your address and other information. And when that information is changed, you have a right to tell the person, rectify it. Here is the backing materials, and you send that information, now ask it to be, and then ask the bank to rectify it. Up to this point of time, it was up to the bank. It was up to the relevant recipient of the data. But now the data subject has a right. The reason being, if the inaccurate data is used to make a decision, that has an impact on me. So that's another right that is given. In addition to that, there is something called automated decision. In the modern day and age, using AI and other algorithm, you make decisions. And sometimes some of those decisions are solely automated. If it is a solely automated decision, then the data subject has a right under certain circumstances to ask the controller, that is the data processing entity, review that decision. That means human intervention. Because if he believes that this has a irreversible impact on me, irreversible and a continuous impact on me, then he can invoke that right and ask the entity to review that decision using human intervention. So those are some of the fundamental rights that are given to the data subjects.
So as we can see, over the years with the introduction of the PDPA, there are quite a few key areas that have finally been given some sort of rights towards the individuals that have their data processed, in order to ensure that it's not an unfair game and it's not unbalanced. The right to be forgotten, specifically you mentioned, as colloquially mentioned, is a very big topic among the social circles as well. I want to talk about the other end of the spectrum, which is the obligations that the organizations and also data controllers have when it comes to this law. What we just spoke about were the rights awarded. If you could give us the flip side of the coin, sir, how exactly are data controllers and processes, as you mentioned, really held accountable under this act?
Yeah, actually, as you said, it's a flip side of the coin. Basically, whenever you give rights to somebody, it becomes the obligations of the other party who's dealing with him. Example, when you are an employee, if you are given rights as an employee by the law, it becomes obligations of the employer. So those rights are founded upon principles. And those principles and rights in turn becomes the obligations of the controller. If I give an example in this way. Now, to create a fair market where the personal data is being used as a commodity, but simultaneously I am able to participate in that process. That means I need to know how you process data. That's the principle of transparency. We hear this term privacy notice. The foundation of that is the principle of transparency. So in the privacy notice, I have to tell the data subjects, these are the purposes for which I use your data. This is how I use it. These are the rights you have. And this is how you exercise it. If you are not happy, you can complain to the Data Protection Authority. So that privacy notice becomes a reflection of how the data is being handled by the organization. So the preparing of the privacy notice, ensuring that the information is available to the data subject becomes therefore an obligation of the controller. So likewise, then especially with the data protection law, one of the principles that came into effect is data minimization. Meaning, up to this point of time, we had the freedom to collect data as much as we want. If our ERP system says this is the form, collect all that data, then you tell the data subject, unless you give me this data, I'm not going to provide you my services. That freedom is completely taken away. Unless I have an objective necessity to process personal data in the first place, I cannot process personal data. That means, as you know in the law, subjective necessity is not important, objective necessity. If I can provide a particular service without obtaining personal data at all, what the law requires is, then don't process personal data. But if there is an objective necessity, say for example, I order something over internet, and obviously the trader requires my address, name, and the contact number. So that is the objective necessity. So then data minimization would say collect only those data. But if he also decides, I want your email address, or I want in addition to the home phone number, you have given us a personal phone number. So whether that is the objective necessity or not becomes a factual test. If it is objectively not necessary to fulfill the delivery contract, then you cannot take it. So that is data minimization. Then you have the transparency. Then other key thing is that when you process personal data, first you need to have a particular purpose in mind. So this is the purpose, and that purpose has to be legitimate. To ensure that, the enactment says always whenever you select a purpose, it has to have a lawful basis selected from the enactment. So I'll give an example. Now let's go to the example of delivery contract. Delivery contract, up to this point of time, we simply enter into the contract and they get the data, I get the product. But the enactment says, because I have to ensure I put in place a compliance mechanisms under the enactment, I have to select a lawful basis there. So what would be my lawful basis? Performance of the delivery contract. If I also plan to subsequently send him marketing messages, then my lawful basis likely be consent. So I need to ensure that I select and identify those two separate purposes, figure out the respective information. I also need to figure out how long I'm going to keep that data so that right to be forgotten can actually be granted. And if the consent is the basis for marketing purposes, which it has to be, then right to withdrawal need to be facilitated. And in addition to that, the number one thing that is coming from the enactment is your claim of that I am compliant is not enough. If the Data Protection Authority asks the question, how are you compliant? Then I should be able to produce the records of processing. That is from A to Z. This is how I process this personal data. This is how I safeguard, meaning one of the biggest challenges in the modern day where the cyber crime is actually one of the biggest threat to the global economy, data leak. So one of the mandatory requirements, another principle is integrity and confidentiality. So you need to put in place all appropriate safeguards. If it means if you need to get ISO certification for information security, then you need to get that. So that's how the principles in turn becomes my obligations. So the emphasis there, the key thing of the data protection law, because this is inspired from GDPR, is records of processing. Everything needs to be documented. Selecting of the lawful basis, then the types of data that I use, the sensitive data that I use, and the particular lawful basis. And if I'm using a sensitive information, I need to have an additional condition fulfilled, how long I'm going to keep that data, and the mechanism to enable the rights of the data subject, all that needs to be there in the documents. So if the data protection authority asks for the records, I should be able to produce that documentation, and we call it ROPA, records of processing.
Right. So clearly, the introduction of the Personal Data Protection Act has ensured that these safeguards are going to continue to stay in a very firm capacity, specifically because of ROPA. As you mentioned, there is an obligation to keep it documented in order to ensure that the process is stuck to it, and also the authorities can actually keep the checks and balances for organizations that process data. I want to get into specifically how the PDPA, the Personal Data Protection Act, actually impacts how Sri Lanka does business with firms abroad. And the global impact that it has in having it locally effective in our country. Before we get into any of these specifics, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back. Welcome back to Law, Land and Liberty. We're in conversation with Mr. Shanaka Gunasekara, attorney at law. We were in discussion about the Personal Data Protection Act. He is a partner at FJ&G Deserum and is also the head of data protection and privacy in the firm as well. So, sir, I think we had a very good previous segment, a good initial understanding on what exactly the obligations are on the controllers and processors end, and also the rights awarded to the individuals that are having their data processed. Now I feel like we have to get into the practical aspects that we have the basics down. I want to ask you, sir, specifically with the activity of the PDPA in Sri Lanka and its effectiveness, how exactly does that play into how foreign firms that require data collection and processing and also in that field really interact with Sri Lanka? How has it changed moving forward? And also firms like FJ&G Deserum specifically might have had a lot of introduction when it comes to how foreign firms actually tend to be active in the country following the implementation of these laws. Can you please walk us through that, sir? Yeah,
so as you know, the strictest law in the sphere of data protection is GDPR. So EU GDPR requires data controllers there to process personal data only in a safe environment. What it means is that the EU GDPR, like our personal data protection law, provide a very stringent framework giving data subject rights and also ensuring imposing requirements in relation to data security. All that is very clearly spelled out in GDPR. So if the data of, let's say, European Union citizen or resident goes out of European Union, and if it goes to an environment which does not have an essentially equivalent framework, it means that then that data can be exploited. Say, for example, if it goes to a country which is subject to mass surveillance. Let's say, for example, if Sri Lanka passes a law saying all ISP traffic will be monitored to figure out whether any person is engaging in any unlawful activity. That's an act of mass surveillance. So countries like Europe, especially the EU countries, are very much interested in figuring out whether data is going to countries like that. Because if it goes to countries like that, the level of access that those countries will get to that data is considered highly intrusive. So, especially in our IT segment, when those companies try to provide services to, let's say, EU-based entities, they face this issue that because sometimes they will need to access the personal data of EU residents. Say, for example, there's a university in the European Union, and there's a developer in Sri Lanka, or there is a outsourcing entity in Sri Lanka which wants to help in bug fixing or even developing certain modules. So in that process, they might have to access personal data of EU students. When that happens, the first thing, because of the GDPR requirements and the heavy penalties that are attached to it, what that entity in EU does is it contacts a law firm there in EU and asks whether Sri Lanka is a safe place to send the data. And we call that, under the GDPR, transfer impact assessment, because the GDPR necessarily requires that assessment to be carried out. So then, unless Sri Lanka is declared as an adequate country, so under the GDPR, there are a list of countries that are described as countries with adequate legal framework. Sri Lanka is still not among them. So if data is to be sent to Sri Lanka for processing, that law firm would then in turn retain a law firm in Sri Lanka, would say, here is the transfer impact assessment, I want you to fill this in, and then sign off saying Sri Lanka is adequate country or inadequate country. With the Data Protection Act came in, we were able to sign off saying Sri Lanka is an adequate country, but subject to the enactment being brought into operation. So as at date, Sri Lanka is not a country, safe country to send the data. This is why I think ICT sector specifically lobbied for this legislation, because this particular law is required to bring in the much needed foreign currency to the country.
That means with the PDPA being introduced, are we at a conventionally better standing, but we're still not completely there? We're not under the list of accepted countries with accepted legal systems that have proper protection. Does that mean that the PDPA not being enough to list us as such a country requires us to do extra effort in order to enact more legislation, or is it simply a practice issue?
I would say because the transfer impact assessment under the GDPR is actually not limited to the Personal Data Protection Act. They look at A to Z the entire legal framework, how effective it is, how independent the judiciary is, all that is being looked into. So that's a fully fledged assessment to figure out whether legal system is effective enough to protect the personal data and honor the rights of data subjects. And our conclusion, actually looking at the Sri Lankan legal system, because we have a constitution, independent judiciary, all that, if the PDPA comes into operation, so far we have opined, and under the transfer impact assessment, Sri Lanka is an adequate country to send the data. And our foreign legal partners, having evaluated that assessment, have agreed with that in more than one occasion. So that means Sri Lanka, once the PDPA is brought into operation, even though we are not listed among adequate countries, even though we are not listed as one of those countries, we are still able to provide services and carry out our trading activities. In terms of getting us included into the adequacy list, that's the decision of the European Union relevant authorities. So they would study our system, and then they would come to the conclusion eventually that we are an adequate country. That will make us things easier. But in terms of what else needs to be done, I think we are there if the law is properly implemented.
The implementation is, of course, an essential nature. Unfortunately, we have seen that we might have a lot of drafting of legal frameworks and legislation, but the implementation, the practical aspect is where we fall behind. Specifically, you mentioned, sir, that everything that can be done in terms of implementation has mostly been done in the country, and it's simply a process of implementation, and in order to ensure to the authorities of the global community that we do maintain best practices in the country. I want to move along, sir, specifically when it comes to how the PDPA compares to key pieces of legislation, like you mentioned, the GDPR. Do we have in this piece of legislation adequate protections in comparison to other international acts and legislation that we have seen?
Yeah, so this enactment is, I would say, fully inspired by GDPR. So the from A to Z, even including definitions like controller, the consent, the processor, the processing, everything is borrowed from GDPR. So this is not a criticism, but what I would say is Sri Lankan enactment is like a extreme summary of GDPR.
Right.
GDPR has 170 plus recitals, 100 articles. It's a very lengthy document.
Extensive.
And the purpose is that the EU has this approach that we ensure that whenever a person reads the law, he fully understands it. So there is this transparency at next level. So we as a jurisdiction, when it comes to passing laws, we are not there yet. So what we have done is we have sort of borrowed the skeleton and implemented so that but simultaneously, that means that we have adopted the best international standard in that sense. So that is why, in fact, we were able to sign off transfer impact assessments saying, okay, Sri Lanka has an essentially equivalent framework. So in that sense, except certain lacunas, because I think there are challenges, say for example, one of the rights that are available under the GDPR is right to data portability. So let's say, for example, I go to CEB today and then submit my details for an address change. Then tomorrow, if I go to the water board, I have to submit those details again. If the right to data portability was available, and then I should be able to compel that entity to transfer the data to water board so that I don't have to keep on making submission. That's an amazing right to have, whether it is public sector or the private sector. But I don't think we have financial resources as well as the infrastructure, both in the public sector as well as the private sector, to have those type of rights. But lack of those type of rights do not usually affect the essential equivalence. Because the reason is essential equivalence is it's more geared towards protecting the personal data that is coming to Sri Lanka, especially from public authorities. This enactment specifically built, there's a specific principle that is built into the enactment which prevents public authorities from collecting or otherwise processing personal data without honoring rights of the data subject. So that's the number one thing countries like EU countries are interested. So that is ensured under the enactment so that the fundamental rights and freedoms of the data subjects are honored. So therefore, Sri Lanka is a safe place to send the data.
Exactly. So we have the very basics down, and the very fundamentals of why the PDPA and other such related legislation has been enacted has been protected. I want to ask you specifically, sir, when it comes to the implementation of the Act as well and the enforcement of the Act in itself, what are the timelines looking like right now for data controllers specifically? Because we need to understand how exactly the enforcement, the practical aspect would work in the local setting.
Yes, so it was to come into effect on 18th March. But I think a lot of stakeholders lobbied saying we are not ready. And as a result of it, what the government did is they rescinded that particular gazette, bringing data protection law into operation on 18th March. And current situation is there is a bill, that is amendment bill, that has been put forward before the parliament. And that bill provides for a further gazette to be made by the relevant minister after the bill is passed. And by that gazette, they would declare the relevant implementation date. And so but in terms of when it would be brought into operation, the only guidance we have is a media release a press release that was made by the relevant ministry saying that they would grant additional 6 months type of a time period. So that would mean that the enactment is likely to be brought into operation towards the tail end of 2025.
So we can expect activity when it comes to the end of 2025, but again, we're not exactly sure if there's going to be any changes in the timeline as
well. I think I forgot something, but the Data Protection Authority, the part dealing with Data Protection Authority is already brought into operation.
Yes.
So the Data Protection Authority is established. If you see their website, it's there's a lot of activity there. They have published draft rules, and so those activities are at the moment they are undergoing.
Right. I want to talk about the Data Protection Authority as well specifically, but before we get into the specifics related to the Data Protection Authority and also what we can see in the future when it comes to privacy and data protection in Sri Lanka, let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back with the final segment. Welcome back to Law, Land and Liberty. We're in our final segment in conversation with Mr. Shanaka, Gunasekara, attorney at law, partner at FJ&G Deserum, and also the head of data protection and privacy at the firm. So thank you very much for the previous two segments. We covered a lot of ground. Before we go into the Data Protection Authority that we must talk about, that's already in effect as we speak, I want to get to the other side of the situation when it comes to now. We did speak about how Sri Lanka can be some sort of data processor when it comes to the European Union and other global communities. But how exactly does the PDPA, the Personal Data Protection Act, really approach foreign firms that are active in Sri Lanka and processing Sri Lankan citizens' data? Can you tell us how exactly firms like yours tend to tackle and manage things like that?
Yes, so this is again what we have done is we have borrowed how we have addressed that issue is we have again borrowed the GDPR mechanism with certain modifications. So it means that, say, if you take the GDPR, so one of the challenges that the European Union faces is that you have social media companies and other big data breathers who end up in consume data and process it somewhere else. So what they wanted to do is that they wanted to ensure those companies honor the rights of the data subject and also follow all the data protection principles. They drafted the enactment in such a way that the goods and services provided by them, where they process personal data, they ensured those companies they also come within the definition of controller. So how did they do that? What they said is, if you are offering goods and services to data subjects in the EU, even if you are not within my jurisdiction, then any data processing of that, in that regard, you need to comply with GDPR. In addition to that, in some of the scenarios, you may collect data from there and take it somewhere else. But so if the data is processed even partly within the European Union, then the data protection EU GDPR is applicable. Likewise, there could be instances specifically when it comes to social media profiling, basically monitoring the behavior of the data subject while remaining outside of the jurisdiction. If you do that, yet again you come within the purview of the GDPR. So we have borrowed that mechanism. So any foreign entity which is staying outside of Sri Lanka but specifically doing targeted selling of goods or services to Sri Lankans, and in that process, if they process personal data, they come within the purview of Sri Lankan Data Protection Act. In addition to that, if they do the monitoring of the data subjects, behavior of data subjects in Sri Lanka, they come within the purview of data protection law. If they do part processing of personal data here in Sri Lanka, they come within the purview of data protection law. But one difference is that in GDPR, they have imposed this requirement under certain circumstances, you need to have a representative in European Union. But we have not imposed that requirement, perhaps because we are a small country. If you do that, certain global entities might pull out of Sri Lanka as opposed to providing services to Sri Lankan data subjects.
So we do have protection, and it's not that foreign entities, even though foreign entities are awarded such protections under the EU GDPR, we also have legislation that's in the country that will protect Sri Lankan consumers and having their data from being processed from foreign entities in order to better protection in the country. I wanted to touch on the Data Protection Authority as well. Could you please give us a little bit of an introduction onto the Data Protection Authority, sir, and how exactly they're functioning in the country at the moment? Of course, the PDPA is yet to come into action, but the authority in itself has begun its processes. Could you please tell us about it?
Yeah, so the Data Protection Authority, I would say, is pretty much equivalent to any other highly powerful regulators. So they have the power to inspect all documents. They have the power to come into your premises and check that. They have the power to look into any complaints. They have the power to issue directions. And if a data subject makes a complaint, go into a fully fledged inquiry, and at the end of the inquiry, make the decision asking either you stop this activity or rectify this activity, and if your activity has resulted in a loss or damage to the data subject, order the compensation to be paid. So in that sense, it's a sort of a quasi-judicial body. And with all the powers, adequate, I would say more than adequate powers, given to them to ensure that they are able to fully implement the enactment and to ensure that the data subject rights are granted. In terms of whether they would have adequate human resources or financial resources, that's a different question. But in terms of the legislative framework, I would say they have been given enough powers.
So the basis is there, the implementation is what's left, as we have seen in quite numerous times.
Yes.
So when it comes to, now we spoke about the legislation in itself, I want to talk about the punishment and the penalties aspect of the Personal Data Protection Act and also the authority. Could you please walk us through some of the key penalties that we see listed out in terms of a breach?
Yes, there's a difference when it comes to Sri Lankan Personal Data Protection Act and the GDPR when it comes to violations. Sri Lanka has taken a more sort of, I would say, pragmatic approach. So what the enactment says is, let's say I go and complain to the Data Protection Authority saying company X is processing data in a manner that is not compliant with the data protection law. So, and let's say they start the inquiry, and if they actually find out at the end of the inquiry there is these non-compliant activities, as opposed to punishing in the very first instance, what they do is they issue a directive, and that directive would say either rectify your process or stop this processing, and if I have already suffered damages as a result of pay compensation, and that's what comes in the first instance. So unless I have suffered a damage, loss and damage in the first instance, there are no financial repercussions to the controller. It would simply say either rectify or stop or any other appropriate remedy. But if the controller fails to comply with that directive, then depending on the nature, the severity and all that, then the penalty would come in. And that penalty can range from anywhere from 0 to 10 million per instance. And it is also important that the controller does not develop a track record of incurring penalties. Say for example, I get a directive saying do X, I don't do it, I get a penalty, and then another violation is notified, and then yet again I don't comply with that directive, I go for the penalty, then the enactment says that second instance of where you are heading to a penalty, in addition to the penalty that will be imposed, there will be 2 times more of that because you are a previous offender. So that's the mechanism that we have to ensure that the controllers will follow the data protection law.
So it's very intuitive. We can see that there is basically a building up of how
Correct.
the penalties can actually change, because of course it's not a stagnant response. It has to change depending on what the breach and violation is as well. Unfortunately, we're running out of time, sir, but I'd like to ask you one of the key questions that linger when it comes to acts like these and legislations like these, which is how fast moving everything is when it comes to the world of technology and specifically data privacy, and privacy in itself losing its meaning as a concept in certain frames of our daily lives. I want to ask you, sir, when it comes to the future of data protection and privacy in Sri Lanka, are we heading in a positive direction, or are we stagnating in comparison to how international standards are holding up?
Well, I think with the PDPA being brought into operation, we will be in a good position, without a doubt, compared to where we are at the moment. But simultaneously, there are challenges. Now, say for example, while any legislations like GDPR is really robust in terms of protecting personal data, they are also very difficult to comply with if you are SME company, a SME sector entity, or even a micro industry. And so there is that very clear need to give certain level of exemptions to those, the first tier and the second tier of controllers, so that apart from the basic obligations, they don't have to comply with this PROPA to the full extent. In fact, even under the GDPR, even although they are a set of developed countries by and large, they have given that exemption. So there is a very clear need to end up in ascertaining what type of exemptions needs to be given and what type of sectors, and based on that, legislative intervention is required without a doubt to give those entities exemptions from the obligations to a certain extent. So that's one of the biggest challenge that we are facing at the moment, because if that is not done, Sri Lanka still, I believe, the SME sector is about 50%, and that entire sector will be affected, which is not good for the economy. So as opposed to facilitating the digital economy, it can actually destroy the digital economy. So the need to recognize their financial capacity and other resources is a must, because we have borrowed realistically the most stringent legislation in the world, and need for customizing that to suit Sri Lankan requirements, therefore is a must.
Exactly. There's a long way ahead, a long road to go, but I feel, as you mentioned, with the implementation of the PDPA, we are taking a step in the right direction. We just have to ensure that all bases are covered, and it's not just a reenactment of the GDPR. We have to make sure it's tailored to our local situation as well. Unfortunately, sir, the time that we have to speak to you here today has come to an end. Thank you very much for the explanation that you could provide on this very vast topic. Unfortunately, even though there's quite a bit more technicalities that we can get into, I feel like we'll have to put a stop to it right here. Thank you very much, sir, for coming to the studio.
Thank you very much. Thank you for having me.
All right, well, we'll leave you tonight with the words of British statesman Edmund Burke. Better be despised for too anxious apprehensions than ruined by too confident security. That's all we have for you tonight on Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube page, youtube.com/otherderana English. Thank you very much for watching. Have a good night.